Judge.
Welcome back to Law News Network. I'm Heather Hansen, and so excited to have my fellow host here, Aaron Keller. I don't often get the chance to talk to you
not on the air, at least. I mean, there's always conversations in the side wings,
That's
but
right.
not here. For whatever it seems to be, I'm here with Jesse and Misty, but not
Not you and I. I know we talk when we pass, but we don't get the chance to talk about cases on air, and I'm happy to have the ability to do that here because I know that you have done a deep dive into the Adam Matos case. And I want to talk to you a little bit about the timeline that you have sort of developed about the facts of this case. What do you find most interesting in all the work you've done thus far to sort of put this out in a chronology?
Okay, so first of all, we just put the chronology up on LawNewz.com, so anybody who's watching who wants the context can go there. We're going to try to do this more and more with more of the cases we're covering for a couple different reasons.
Help.
A, it helps the audience, and B, it helps us.
That's right.
Because the dates are really critical in this case. I think that the strangest thing here is that the defendant had said time and time again, okay, that he had left the property on the day that they believe the murders were committed.
That's right.
His version of events is that there was this domestic violence call that morning. He got out of there, and he claims he knows nothing about what happened at that point. Well, guess what? All of the neighbors saw him in the area day after day after day after day. So that testimony, which we presume is going to be coming up soon.
Right.
All right, you know, the state's kind of going methodically through things.
Very much so.
But the key testimony here is really going to be the neighbor. And he's going to say, hey, look, you know, I saw them right after they moved in.
Yes.
Okay. Met them all on the 4th of July, helped the family with a few things. This neighbor was entangled in this in many, many ways.
Right.
Right up to knowing that Gregory Brown, one of the victims, the father, okay, was working on his RV. And not surprisingly, we go and get the police records eventually that indicate he was going to buy spark plugs for it. Well, he had talked to the neighbor about this. The neighbor knew what was going on.
Yeah, this is a neighbor. It's not like a neighbor that we've seen in some of the other cases where it was just peripheral. We'd sometimes pass in the driveway. This was a neighbor who knew the comings and goings of this family. And we believe that he will testify that he saw Matos in the days following the 28th.
That's what it seems to be, yes. And so much of what, and look, this is why he's such a great witness, because he's observant, okay? And they have been able to corroborate what he has said. The neighbor has said, I saw him here. He asked me to go there. He asked me to take him out to the bars one night.
And let's talk about something that Kathy brought up off air. What's going on with the child? You know, we've got Tristan, who is the child of Adam Matos and the victim, who now is theoretically being cared for by Adam Matos. But when he's off to the bar with the neighbors, who's taking care of that child?
You know, we don't know. And that's one of the big what ifs that I think Kathy was great to have first pointed this out, because I'm trying to plug the timeline together. Right. And it's like, well, wait a minute, where is the child throughout all of this?
Yes.
And I don't know. His version of things is that the child was with him the whole time, and he winds up at this motel near the bus stop in Tampa.
Right.
Okay, presumably waiting to get the next bus out of town in the morning. He thought he was going to be able to get out of town faster.
Well, yes. And you know, some people pointed out in the chat room that perhaps if he had gotten out of town faster, he would not be sitting there in the courtroom. But the fact that he's like hanging around, ordering pizza, selling dogs, buying shovels. I mean, this case seems pretty airtight against Matos, doesn't it?
It would seem to be. I agree. You know, and then the other side of my head always flips over, and we were just talking about this off the air, so let's say it the way we were saying it here. This guy looks as guilty as the day is long, okay? But I have rarely seen a case with as strong a batch of third-party liability evidence as this case. We know that there's this woman in Kansas from the pretrial depositions.
Well, you know this, but let's back up a little bit, because not everyone watching knows this.
Yeah.
So tell us from the very beginning, who is this woman in Kansas, and how does she play into the defense's purported defense?
Well, see, this is the big thing. We know the defense didn't give an opening statement, and of course you and I were trying to figure out what's behind that. I suspect that the defense is waiting to see exactly what the prosecution throws at the table, because the prosecution had a couple of different avenues that the prosecution chose not to take. One would be to try to get the child to testify, but the child apparently is severely autistic, and there are some serious questions as to whether or not the child's observations and statements are credible.
Right.
The prosecution kept pushing that issue right up until last week. And then finally, right in the middle of jury selection, or at the beginning of jury selection, says, we're not going to call the child.
Right.
Okay, bam, big change right there.
Yeah.
Because
and a smart move.
And smart move, because it opened up a ripe issue for appeal,
That's
a big
right.
issue for
That's
appeal.
Right. And
So-
and also just a lack of credibility there, and a lot of, bringing a lot of confusion to the case that the prosecution doesn't need, right? I mean, they have plenty of other evidence to support their theory.
Look, they've got a lot of great evidence. I don't think that they need the child. The child would have made the case stronger, but it would have given an appeals court something to get in and say, okay, you went too far. And that could have posed a problem. So that was a very smart move on behalf of prosecutors. So as to this woman in Kansas, here's the thing. We know from the court record, okay, and again, this has not come out in the trial yet, but we know from the court record that there's this woman in Kansas who had this and I can't quite define the relationship between victim Nick Leonard and this woman in Kansas.
And what's her name, do we know?
We know it. I haven't been saying it yet because, again, I'm not sure. It's a matter of public record, but she hasn't been called to testify yet, so I just haven't been throwing it there, because for all I know, the defense might not even go there.
Right.
But look, she's in Kansas. She was interviewed by police. She lawyered up. She had this on-again, off-again relationship, fling, flirtation, I'm not sure what to call it, with victim Nick Leonard. She's more than a decade older than him. She's married but kept up this relationship with Leonard on the side. She used to loan him money frequently, thousands of dollars. Leonard owed her a debt. She worked for Verizon, so Leonard had complained about her hacking his accounts within a day or two before the murders.
Well, and hadn't Megan also called the authorities about a woman?
A woman. We don't know who, though. They couldn't figure out who it was. And the reason why is because the police who took the call didn't think it was severe enough to open up an official complaint, and they never dug into it. It's one of these things that it's like, okay, where was the call placed? These call records are pretty easy to get a hold of.
That's right.
Who is going to get them? Does the defense have them? I don't know. Does the state have them? I don't know. Some of it might have come in to Megan Brown's work.
Right.
Not really sure. I don't know if it was to her phone or what the deal was, but you've got Megan Brown complaining to police that she was harassed. You've got Nick Leonard claiming that this woman in Kansas just won't get off his back. She's down there on vacation a couple of weeks before the murders and admits to driving past the house, seeing his vehicle there, and seeing him outside a restaurant, but she claims to have never made contact with victim Nick Leonard. And so it's like, what's going on here? Like, there's some kind of bizarre love triangle. We don't know what the deal is. And that's why I say there's a lot of third-party liability evidence in this case. Most cases where there's third-party liability, we know there's way less than this.
Yes, yes.
But Matos, there's just so much evidence against him that I think that the prosecutors and the investigators made the right call by not charging too far down the chain of
but the defense
looking
can
at this.
really play with this, right, Aaron? I mean, if they're smart, it could be enough to, and this may be why they didn't put on an opening, to present a case against this woman, to say that this is our case, because so often we talk here on the show about whether or not there needs to be an alternate theory. Well, they have an alternate theory, and if they can try to prove that alternate theory, though they don't have to, through the defense, they certainly may have raised the specter of reasonable doubt that, does someone on that jury think it could have been this woman? And is that enough to get Matos free? So many people watching are like, this is a slam dunk, and yet when we haven't heard any of this yet, it could be less of a slam dunk than we think it is.
Well, and this is yet to be seen, because if I were betting, I would have put my chips on this table last week and said, I will bet you everything I've got that the defense is going to come swinging out of the gate and say, you know, this woman in Kansas is really intertwined here, and we think that there's something there. But then they didn't do it, so I would have lost.
Right.
And I don't know if they're just kind of waiting to see if there's some other underlying issue that might come out of the state's case, but if there is, there's not a lot of evidence of it in the record.
Yeah, and it could be one of those decisions that they've made. And I don't do this myself, but I've seen co-defendants in some of my cases do this, where they say, listen, I don't have the burden. I don't have to say a single word. I don't have to put on a single piece of evidence. And just to remind the jury of that, I'm not going to say anything in an opening, and then wait until they have tried to meet their burden to try to counter it. I think it's a little bit risky because, you know, with the whole idea of primacy and recency, the first thing you hear is so important. And when you hear nothing from one of the sides of a lawsuit or a murder trial, how much of an impact does that have on a jury? But there's something to be said for saying in the closing or the opening, if they give it at the beginning of their case, listen, you don't have to hear from us at all. And you may now think that they have actually proven their case, but what about X, Y, and Z? But it's also been interesting to me that how little the defense has cross-examined the majority of the witnesses. In fact, one of our producers said, is the defense just laying down and giving up? And I don't think that's the case. But I think that a lot of the people who are watching who are like, oh, Jan, this is so boring, it's a done deal. I don't think it's such a done deal.
Well, look, I think that the audience is pretty wise in saying that this looks like an open shut case at this point. And here's my fear with the tactics that you just discussed. The defense has been laying and rolling over and not even being present basically at this point. And you just said yourself, raising questions about whether or not that's the wise tactic, because the jury's got to be thinking exactly what everyone else is thinking.
That's right.
Why, if you're going to do the third-party liability thing, you got to hit it right out of the gate. You got to tell the jurors, hey, look, you're going to hear all this damaging evidence against this man right here for days and days and days, but you got to remember in the back of your head, there's this woman who had been presumably stalking two of the victims and was, you know, in this on-again,
right,
off-again relationship with one of them. And what's her relation to thing? Now, part of me wonders, you know, I don't know, was there another pretrial ruling that they weren't going to get into it? Is there something? Because I've read a lot of the court record, but it's thousands of pages long. I haven't been able to do all of it.
Yeah.
And a lot of it's been sealed right up until the eve of trial as
Right.
well. So, you know, I don't know. And the weird thing is that this person in Kansas has every alibi in the world. She didn't get to Florida and do this herself. The question is whether she got somebody else in Florida involved to do it on her behalf. And, you know, if Matos hadn't been ordering the pizzas, okay, and hadn't been hanging around with all of the neighbors.
Right, and selling the dogs and buying the shovel. I mean,
all
there's
of this
just
stuff,
so much.
it's so damaging.
There.
And, you know, if he hadn't been doing this, I would be inclined to believe that this person in Kansas was involved somehow.
Fascinating. Yeah. I mean, listen, the Kansas person may play a major role in coming days, which is going to make this case really interesting. It's definitely a situation where, you know, this case is supposed to go until November 22nd. So there's certainly some time for both sides to put on a lot more evidence and for the defense to start cross-examining people. You know, I do think, like just now with Rhea Clark, the woman who's been on all morning identifying pictures, it appears that there was no cross-examination of her. Well, what are you going to say?
Yeah, what are you going to say?
Yeah.
That's exactly it. You said people are saying, well, the defense doesn't look like it's playing ball here, but what do they have to go with?
That's right.
You got the, you know, the poor grandmother of Megan, the mother of the other victim, you know, the stepmother of one of the other victims. You know, I mean, you know this. If you're defense, you're not going to bite into family members. I mean, the defense hasn't had an opportunity to really dig into the case yet. The person the defense is going to dig into is going to be the neighbor. You seem to know an awful lot about what's going on in this household, don't you?
Did you ever see an unidentified woman? You know, perhaps that'll play into it somehow with the woman from Kansas. I mean, that neighbor could certainly be a witness where we actually see some fireworks from the defense. And, you know, when the defense has the opportunity to put on their case, things may change drastically. But I agree with you. I think that it would have been smart to lay that foundation at least a little in an opening rather than just sort of waiting until, especially because the case is is so long? You know, we've got maybe a whole week, maybe a week and a half before the defense gets a chance to give their say. What is the jury thinking during that time?
Well, you know, what I suspect we're going to see here is based on the pretrial depositions. And look, I'll add a little aside in here. Florida does this. A lot of states, you don't do pretrial depositions in criminal cases. So part of the reason we know so much is because of the way Florida does this. I think all the states should do it because it prevents an unfair advantage on behalf of the prosecution.
Absolutely.
You know, some states don't have open file discovery. One where I'm licensed does. All these procedural things influence the way that these cases are tried. My guess is where the state's going to go with this is we're going to see every single neighbor in this complex on the stand. Some of them saw people that looked like Matos hanging out across the street one day. There's all of this stuff that these neighbors witnessed. This is a small enough community where people saw a lot of things. A lot of people saw the pizza. We've got the pizza delivery people. It just doesn't look good for this defendant, but yet still there's this third party thing with this woman in Kansas. It's just so strange.
Yeah, our chat room is asked, Nellie brought up the Dorothy defense, the girl from Kansas.
Well,
we like it, Nellie.
That's not her name, but that's a good thing. Now, keep in mind, I lived in Kansas City, Missouri, which is right on the border for a while. So whenever something happens in Kansas, I usually do pay attention.
He's going to be ready for it. Karen goes, not buying the stalker did it defense. But and listen, Karen, I get you, but we haven't heard the stalker did it defense, and so it's hard to say. I mean, you and I can sit here and say these are the things that might be argued, but until we hear from the defense on this, it's sort of going to be a situation where they risk something because we see it with our chat room. They have already decided Matos did it, period, end of story. And listen, there's plenty of evidence to make that conclusion, but the defense's job is to insert some reasonable doubt. And thus far, I don't think anybody has any reasonable doubt.
You know, look, part of me wonders, okay, well, where else is the defense going to go? Are they going to try to do some insanity thing? Well, I mean, I'm not familiar with the Florida procedures that intricately to know when do they need to provide notice of that. Are they going to go there? Are they going to just turn around and say at this point, okay, the woman in Kansas has got an alibi. We don't think she's crazy enough to have hired a hitman. Okay, she didn't pull Adalia DiPolito.
Right.
Okay.
Right.
Because there's not a lot of evidence that that would have happened, at least that I've seen thus far. But again, there's some suggestion that people were looking under the covers to see if it did happen.
Right. And the thing is, you know, we had Yosha, one of our frequent guests, on the other day, and she made a point that I really has resonated with me, and I think about it now. And she often says in her closings, it's not enough for you to say he probably did it. That's not beyond a reasonable doubt. You have to be more than probable. You have to be certain. It has to be beyond a reasonable doubt. And to inject something where it's not just probably into this case, the Kansas Dorothy might be enough. You know, Nellie had a good question here. She wanted to know whether or not Matos has any criminal record. Have you seen? I have not. Oh, yes. Okay, so tell us.
Gosh, yeah. I mean, well, look, I'm basing this sort of third hand, but it's, you know, I'm scampering through all of this research. A newspaper reporter in Pennsylvania, where the family used to live, uncovered a wealth of court records related to him, which would suggest.
What types of crimes, Aaron? Were they violent crimes?
I'm still in the process of reviewing them. So
guys, ladies and gentlemen who are watching at home, make sure that you're keeping up with Aaron's postings and the things on the LawNewz network, because you'll see a timeline up there, and you'll see he is doing huge investigative reporting here, and that not all of us get the opportunity to talk about all day long. So keep up with the website and keep up with the articles that he's writing, because you'll learn, Nellie, and I didn't know either, that in fact Matos does have some sort of a criminal background. What's your sense? I know you're not specific, but is it? I mean, obviously he wasn't in jail at the time of this event. Had he done any time, Aaron? Do you know that for sure?
I don't know that off the top of my head, and I probably should, because I've just barely started to dig that far.
And there's thousands of pages.
It's got to do with, well, and these are records that I have yet to find, and they have not moved from Pennsylvania down to Florida. They haven't been filed as part of this. But you know, look, bottom line, if I were representing Adam Matos, I would not put him on the stand knowing what's up there in Pennsylvania, because the minute he goes on the stand, this all comes in. And it sounds, if I'm remembering things, that it fits with what the Brown family has said about him. Quiet guy, keeps to himself, maybe a little bit too much, but when he gets mad, bam,
yes,
he becomes volatile very, very quickly.
Well, and it's going to be interesting because I agree with you 100%. That would lend itself towards leaning against putting him on the stand. However, his reputation is also as being very charming. He is attractive enough that one of the jurors, and you wrote a great article about this, one of the jurors said that he was too hot to concentrate on the trial.
Yeah, and look, I mean, that's an open-ended question. Is that, and a lot of people are saying that juror just probably found a unique way to try to get out of jury duty.
Listen, that's no dummy.
You know, which is probably why the judge said, okay, I'm going to keep this juror way on the back burner, but I'm going to make her keep showing up. I'm not just going to dismiss her out of hand in case that was a tactic. All right, look, I just pulled the article up. Again, this is not my reporting. I'm trying to confirm it, but if this is correct, okay, he had a juvenile issue back in the late 90s. He had marijuana possession, auto theft. He sent to a juvenile detention center for 18 months, felony burglary. Now that's interesting, the felony burglary that's alleged to have happened in Pennsylvania, because the neighbor, who's probably going to be the state's star witness here, testified that at one point the neighbor had locked himself out of his own house, and Matos picked the lock like that. Made it work just like a charm. Okay, and that's in the timeline that I put together for LawNewz.com, so this is kind of interesting.
Well, and that's really interesting. You know what else is interesting? You said he did 18 months in a juvenile detention center. You know, we've had so many guests on, that one in particular, that mayor from California, that woman who we've had on as a guest often, and she's talked about how oftentimes it sounds as though, and I know that you'll do more reporting and put it up on the website, but it sounds as though his background has not been violent thus far, or if it did, it progressed to that. And it sounds as though sometimes we see that people go to juvenile detention centers or to jail even and come out far more violent than they went in, because these crimes that are alleged against him are terribly violent crimes. It's not,
well,
you know,
it increased eventually. So he starts with the marijuana, then it's auto theft, then they allege that he went on some $26,000 crime spree.
Wow.
Through his neighborhood. Okay, so this is between 99 and 2001. You know, he had a simple assault and trespassing in 07, according to this newspaper article in Pennsylvania. And then eventually the accusation is that he broke into the apartment of a woman he had dated 18 months earlier, and when she returned home with a male friend, he is alleged to have attacked the man before stealing the woman's cell phone and keys.
It's the same thing. It's the same. If you believe this case against Matos, there are a lot of similarities there in a jealousy problem.
Drunken driving, harassment, retail theft after that. And, okay, so what you see here is an increasing set of trouble, and again, I'm trusting that the local reporters in the Lehigh Valley of Pennsylvania, Lehigh Valley of Pennsylvania, to Allentown, Harrisburg, whatnot. So I'm trusting that this is correct. I really want to read the documents myself at this point.
Of course.
But it just adds up to this strange situation, and you know, and here's one of these other things. It fits with so much of what is in the Florida record that I have read. For instance, one of the relatives, and the next piece that we're working on for LawNewz.com that should be up within a matter of hours if it's not up already, is to dive into what was going on in those couple of months in Florida. Why did they move to Florida? One of these things jumped out at me in the depositions that really, I think, was telling. One of the Brown family relatives said Adam Matos' presence down there. So let me back up. He was brought down because he's the father of the child. And when the Browns moved, they thought, well, he's going to have to move because you can't just randomly take a kid out of state away from a father. Okay. There's a lot of detail in this article that should be up shortly. But one of the relatives said that his presence in Florida was, quote, a necessary evil.
Oh, boy.
And so something tells me that people knew what was up with this.
Yeah, and that's a difficult decision for a family to make, right? Because the parents, the mom had a job that she wanted to go to, and she wanted to be closer to other family members, and so they're taking the child, Tristan, I think is the 4-year-old boy's name, from Pennsylvania to Florida, and apparently opened up the opportunity for Adam Matos to accompany them, and now are probably, you know, in retrospect, a very bad decision. It's going to be a fascinating case. A lot of this evidence evidence is going to be really interesting to hear. And I think that you've answered the question that's been sort of niggling at my mind, is whether or not he would testify. We've got Light on our chat room saying that the Matos is gorgeous. So we certainly have. He's a good-looking young guy, and that can, as one of the jurors said, impact the ability to judge him. And so, if he was very charismatic, perhaps his attorney would think of putting him on the stand, but not with a background like the one that you just described. Especially because there's enough similarities there that type of behavior certainly would most likely get in on cross-examination, and then he would have some real problems. So the defense is going to have no choice but to go with, I think, in my opinion, go with this stalker as a potential source of reasonable doubt, because otherwise there's just nothing, Aaron. I mean, you may as well just not lay down. There's just nothing.
Yeah, I mean, part of me wonders if the only other place that they could go is to potentially say that this was such a volatile environment in Florida that he snapped or something, that there's no premeditation. I mean, maybe that's, you want to know what, maybe that's their game. That just dawned on me. Because here's the thing, and I just put this is the next piece that's in the queue right here on LawNewz, so I'm hoping it's going to be up shortly. But this relationship in Florida degenerated. So they moved down on July 2nd. The neighbor meets them on July 4th. The other relatives are helping them get situated and everything. Margaret starts her new job. Gregory's on disability.
Margaret's the mother.
Yep.
And Gregory's the father.
The father. Mm-hmm. He's on disability. Megan is working.
That's the mother of the child.
She meets Nick Leonard at this bartending job that she picks up. Mm-hmm. Okay. Matos isn't working. He's supposed to be. The father starts to get down on him for not working. There are explosions between Megan and the defendant about how to raise the child.
Right.
He's more of a disciplinarian. She's more of the type to apparently smother the child with kindness and love. And they start fighting about this to the point where other family members are having to get in the middle of their confrontations because they were going off on one another, presumably he more so than she.
Right, sure.
But this sounded like a powder keg, and it seems to me that, okay, I mean, I don't know. Are they going to use some of these statements, the necessary evil quote and the depositions? Are they going to use this to try to say that this was just a pressure cooker and that he eventually snapped, and try to say that it's not
right.
first-degree murder, but second? Because if that happens, well, it might save his life.
Yeah.
I don't know.
That's a fascinating theory as well. It's frustrating and yet interesting that the defense hasn't given us any sort of tip of the hat to give us a sense of where they're going. And we could have a better sense once cross-examination of some of these witnesses really gets going. So far, the witnesses that have been called have not been key to the theory or to any defense, and so they haven't been highly cross-examined. But if the defense starts picking it up and giving some cross-examation that gives us a tone of where they're going, it would be helpful in analyzing this case.
Look, I'll argue out of my own theory right now. I don't know if they're going to be able to go there because we already had one of the relatives on the witness stand, and I don't think they went there with her.
Yeah, they haven't done anything. They haven't done anything, and so I think that for so many months here together at LawNewz, we've said, well, what are they waiting for? I think even in War Machine, we were sort of like, well, what's going to happen? When's the defense going to kick in here, sort of? And sometimes they don't always kick in, and here it'll be interesting to see because so far it just seems as though there's been really no argument. Now, again, this is the type of case that maybe that Matos was willing to take a plea, and the prosecution may have said no go. This is a death penalty case, and so they may want to pursue the death penalty all the way. So there's a lot. Ladies and gentlemen, I've got to remind you, make sure that you're checking. If you're following this case, it is so worth your while to follow the articles written by Aaron and our own Ron Blitzer up on the website, to follow this case and the timeline, the specifics, the information that Aaron is gleaning from all of these documents, because it gives you some great background. I want to segue a little bit and talk about another death penalty case that we covered here at LawNewz Network that ended late on Friday and that we have not given huge shrift to, that I want to make sure that we talk about. And Aaron, that's the case against Luis Toledo. Late on Friday, the jury came back and gave him life in prison as opposed to the death penalty. Were you surprised?
A little bit. I thought for sure that this would be relatively ripe for and I nuanced my own argument within itself right there. Killing kids.
That's it.
A conviction for first-degree murder of kids. Bad. Okay. He's asking for death. They hear the evidence that he tried to commit suicide in the middle of an interrogation. Who knows what was going through the minds of the jurors, but a couple of possibilities. One, maybe they figured, well, he wanted the so-called way out of suicide. We're going to make him live with it.
Well, and let's go back to that, because I think that's an important point. The jurors apparently didn't hear him say that he wanted death because he said that after the verdict came in to the judge. But you're right.
But they did know about the suicide
You're
attempt.
right. They knew that he wanted to commit suicide, then he knew that he wanted to be with his family. And you're right. One or two of the jurors or more may have said, you know what, we're not going to give him what he wants. Let him live this life knowing that he's done this. That definitely could be a reason that did not happen.
I would be more inclined to believe that perhaps the jurors who hung on this, okay, because it was, in order to get the death penalty in Florida, you have to have a unanimous jury. Okay, I don't think they were unanimous, and that's why we wound up with what we wound up with. It may be that the jurors who didn't vote in favor of death either conscientiously were a little bit bothered about doling it out in this particular circumstance. Mm-hmm. Maybe some jurors bought into the theory that, okay, well, even though they convicted him of premeditated murder, that maybe
because of the cheating and so forth,
there was some, which would result in an incongruity legally, but maybe that played into it. I would suspect that those are possibilities. I suspect rather that the lack of the bodies may have been the real issue, where they said, okay, we're 99.999999999%, you know, but do we want to send somebody to death row? And then
I think so often people think that they could give the death penalty, and then it becomes, it's a very difficult thing to do. And our chatters have been talking pretty extensively about the death penalty. And, you know, I think that someone was noting that the cause of death is listed as homicide when someone is given the death penalty. I mean, it is not an easy issue. And that's why we in America debate it so strongly. But I do want to throw to the clip of the Toledo verdict, and also give us a chance to do some stuff with our tech while we're at that clip. I want to thank Aaron. Aaron, I just want to let you know that one of our chatters has already been looking at your timeline, and that you work with Kathy too, right? We want to make sure that we note that. And they're noting that it's incredible. So for those of you that want to be following this case, check out that incredible timeline.